Hello, everybody. It's Rick. It is October the 17th, 2018. If you need to reach me, my email is rick0327 at me.com. Please keep the emails brief, okay? I do not need to um read your trials and tribulations, okay? You know, it's not that I don't want to read it. It's like somebody sending me a picture of a dead puppy. Okay, I honestly, I don't want to know what's going on other than you're facing a child support situation. Okay, it's active. Okay, or you believe that the support order is void, or was created in violation of due process, because this happens to a lot of people that uh, you got screwed over. They took advantage of your ignorance. The attorney that you may have had took advantage of your ignorance or told you you had to, and you just felt something. Listen, something. It's funny how they say that the what is it? Youth is wasted on the young. Like if I knew what I know now, because it took me all this time. I'm 50 years old. It took me 50 years to learn a lot of things. But one of the things that I've learned is I learned to trust my instincts. Like it just, your body, you could feel it, okay? Uh, you just feel when something's not right. Trust that feeling, okay? Trust that feeling, all right? And if you feel that something's not right, go do your research, okay? Go home. Don't, if you feel like a lawyer's lying to you, if you have an attorney, go home and double check, all right? Because if you feel it, it's probably right. Okay, so maybe you found out that the support order is void. You went, you're doing your research, you came across my channel, you know, maybe almonds and other people, you know, and you want to do something about it. All right, there's no guarantees. I had a guy reach out to me yesterday. He's like, "Hey, Rick, look, like they look guys looking for a guarantee." He was, nice guy. I'm not, you know, And I was like, dude, if I could give you a guarantee, I'd be asking for 10 times the amount of money that I'm asking. I mean, and you'd gladly pay it. And if I was able to give you a guarantee, would you not gladly pay, 10 times what I asked? I would. Okay. You just want the hurt to go away. Okay. But there are no guarantees. What we're dealing with a gang. These judges and lawyers. Boy, do they stick together. I mean, you got to understand, and I've said it in a lot of my videos, that child support is a big revenue stream for the state, and it's also a big revenue stream for these lawyers. There are a lot of lawyers walking around with briefcases in these courthouses just for this child support scam, and you know, it, and they know it's a fraud. Um, when I started doing my own research and started, representing myself, and I discovered that uh, there are a group of people. There's like myself who I don't fit in that group of people where my ex-wife worked. My ex-wife never received welfare. I'm divorced. I have absolutely no business being in the family court. Uh, a few years ago, I was going to a doctor, and I mentioned to him what was going on. And he's like, "What are you doing in family court?" There's a doctor saying this to me. He goes, "You're not supposed to be in family court." Because what happened was his daughter was going through something, and he learned by helping his daughter, like, yeah, and it does make sense to me because, uh, you know, that I'm not supposed to be in that building. And even in the state constitution of New York says that family court has no jurisdiction on divorce agreements, New York divorce agreements, okay, where the child support is agreed upon. It has absolutely no jurisdiction. You're supposed to be in Supreme Court, all right? But these lawyers aren't going to tell you that, and these judges aren't going to enforce it because a lot of them would, there'd be a lot of lawyers not being able to pay their BMW payments and their mortgage and their second house mortgage, wherever their vacation home is. So, there's a lot of things that are working against us, but you still got to fight. Okay. Let me show you a couple of people who fought and were victorious. Okay. One guy, Courtney, he uh, followed my videos and Amen's videos, and he learned from us, and he went to court ready to roll. And all he did was demand. He went up against the attorney for the state child support agency, which is another. I can go on for another 10 minutes with that nonsense. Uh, a state cannot be injured. Okay, and the state has to prove that you entered into a contract with them, and that's what Courtney did. He demanded to see a a debt agreement, proof of debt, and they withdrew the case. Okay, so what do we got here? Okay. Okay, so on Friday I received case dismissed, 22nd, second court today. I send you proof on Monday. Thanks for all your videos and big up to you and I'm Osiris. Couldn't have done it without you two. God's power shines on the downtrodden and gives strength to the weak, refuge for the people and shelter from the storm. I testify you are the truth. May peace forever keep you. And then yesterday I received proof uh, from Courtney. So what happened was I asked him, did he use my paperwork? He didn't use my paperwork. He made his own paperwork. All right. So, that's fine. So long as again, I'm not hooking my paperwork. If you want to create your own paperwork based on the information I provide or what Amin provides and other people, go right ahead. It's, you know, uh, I'm happy. And I told him, I said, I'm happy for you. I just wanted to know if he used my paperwork. So what he did, he created his own paperwork. And a lot of people do that. So I sent, he demanded proof validating the debt, simply asking that they show me the contract that created the debt. Then I used their response papers against them in open court. Everything I did took place in their courtrooms. All right. He wanted to tell me in a conversation. All right. But, this is good enough. Okay. Honestly, guys, nothing. I try to stay off the phone. I have my reasons for it. Not that I don't like you guys. I could be on. I'm a nice guy. Most phone calls end up being 45 minutes to an hour. That's just the way it works out. Okay, and I'm not prepared for that anymore. Honestly, sorry. Um, so this is what he got in response. Okay, Missouri, right? 22nd Circuit Court, State of Missouri. Count one, non-support. Total arrears excess of 12 monthly payments under order of support. Comes now, Kimberly, blah, 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 Assistant Circuit Attorney, enters a memorandum, null, process. What that means is that they could later on bring the case back, okay? If they, you know, in other words, they're leaving themselves the option that they can bring him back to court. Who cares? Right now, his life, he's not paying child support. He doesn't got to pay them arrears, okay? That's okay. All right. And for that reason, the state elects not to proceed. Okay. Beautiful. So, that's a lot of money. 12 months. All right. And victory, as far as I'm concerned. Good job. Courtney, great job. Excellent. All right. And then I have Angela. Angela used the credit paperwork. Okay. You always want to. Anyway, you may not recognize me. Months ago, I made a donation. It was under my old works email. These bastards are relentless, as you know. It's very true. They are relentless. This has taken time and persistence on my end. It does. Listen, it takes a lot of work. Honestly, it does. It's rough. I mean, no one wanted to hand this off. No one wanted to pay a lawyer more than I did. I really did. They are relentless, and it's a battle, man. I mean, I'm just thinking about it now. I mean, the day when I went to court and the judge stayed the order, I wanted to cry. I mean, they beat the shit out of me, literally. I mean, they know it too. I mean, they're unbelievable. But I never gave up, and that's what Angela's saying here. So the county child support enforcement agency knows I have kids. They put it on credit. They put it on their credit, okay, and that's what they do. So what happens is if there's a default or whatever, uh, an order, they send it out to everybody, okay. They'll send it to the bank. They send it to the credit agencies. It happened to me. I one I thought my case was over myself. I'm gonna talk about myself. My case was been over in December of 2012. Okay, it was the last court hearing, and I guess what happened was they were like, "No, you can't let this guy go," because I had a pension, I had workers' compensation. So I'm going for a car, at least my car. Next thing you know, I'm finding out this stuff's on my credit. It was crazy, and to get this taken off your credit's a lot. Seems like a lot of work. I did my own research. With uh, people that deal with debt, and I created some paperwork. Nothing fancy. It's nothing fancy. Okay, it's like one sheet of paper. It's nothing fancy, but it works. And she used it, and right here right Ohio Department of Human Services account removed from report. Okay, so she got it taken off her report. That's a victory. Okay, for some people, that could be stressful right there. I mean, you don't realize in these times that you need a credit card sometimes. If not, you got to deal with cash. And I know it happened to me. So she's still dealing with them. I'm almost done with these folks. Thanks. Good job, Angela. Congratulations. Okay, a couple of victories. All right, it's important to show people that people do win once in a while. I do have people that don't want me to post it. Okay, I'm not saying it's a lot. Okay, we are dealing with a giant organization here that doesn't matter what you show them, they won't dismiss the case because they all stick together. But there are people that win. All right, so here we're dealing with how to vacate a default judgment. I cannot find it. I just had, that's what made me make this video. I had one of my subs win. He had his default judgment vacated, and I started making this video. I made these slides a couple of weeks ago. I cannot find the friggin' email. Okay, so whoever you are, if you want to shoot me the email, and I'll show you your victory. So he had the default judgment vacated. Okay, using my paperwork. Okay, so anyway, what a default judgment is if you don't show up to court, they issue the judgment as if you were there, and they hammer you whatever information they have, and they without you there, the other side submits information, and next thing you know, they'll say, "Oh, you owe $800 a month in child support," and then they'll go back, 5 years, and next thing you know, 800. You're talking about $45,000. Okay, all from a hearing where you weren't there. Default judgment. It happened to me. Okay, they never notified me for court. They had a hearing without me because that's another thing. Hey guys, if you got this is something I recommend you do. If you're in court right now, right, and you're dealing with these people, you know what you do every Friday? Get on the phone if you can. Call them and make sure that you're not scheduled for hearing. What they do, and I caught them myself. What they do is they schedule hearings and they don't notify you, and they claim they did. They claim they dropped it in the mailbox because that's all they got to do to notify you is do it by mail. Okay, doesn't have to be somebody handing it to you. Like most state uh, laws for process service of process can be done by mail. Okay, and so they'll claim they dropped it in the mailbox. You never got it, and next thing you know, they have a hearing and you're not there. And I caught them doing that with me. I went to court one day to get some print out some paperwork, and next thing you know, it says I had a hearing like a couple of days before, and then I saw I had a hearing scheduled in 2 days. This was in February of 2013, and I showed up, and they didn't know what to do. Okay, but to make a long story short, what I'm proving is they do stuff like this. So you might want to go and just make sure you're not scheduled for any hearings that they notify you about, because then they'll I've gotten plenty of emails from people like, Rick, They never notified me of court, and I got in the mail a default judgment. All right. And this is for if you have one now, you want to vacate it. Okay. So oftentimes child support proceedings occur without the appearance of the respondent. And what occurs next is they issue a default judgment. They'll issue an income withholding order. They'll suspend your driver's license, and they'll suspend your bank account. Also, they may suspend your passport. Okay. Um, so this is what a court needs to prove. Okay, for a default judgment. All right. Uh, they have to prove you and the child support agency entered into an agreement. Okay. See, they don't tell you this stuff. They'll just tell you that you're in default because you didn't show up, which is nonsense. You don't have to appear unless they have proof you are required to appear. Well, that requires proof of a contract. Remember, they call you an obligor. They say you owe a debt. Debts are contracts. Contracts require, they're supposed to require uh, two knowing parties or voluntary entering into an agreement, a contract. Okay, so like I just showed you before, with Courtney, it was the state of what was it, Missouri against him. All right, where's the proof that he entered into a contract with them? That's what he did, and you know he was victorious. So that's what we're gonna do. All right, they need to prove that you were properly served, that you acted willfully by purposely not appearing. That's huge, by the way. All right, that is another thing. They need to prove with default judgments and in most things, they need to prove that you acted willfully. Okay. Now, if you were not properly notified, that's an excuse. Perfectly uh, that's a perfectly good excuse to have a default judgment vacated. Okay, you cannot be held responsible for something that's what happened to me, by the way. So they have to prove willfulness. Okay, that's also a child support. Okay, so whenever they claim non-payment of child support, they have to prove that it was willful. Now, they do this to a lot of men, right? Let's say this happens to a lot of men. Hey, Rick, I got a lot of emails like this. Rick, I found out I got a child. They're telling me I owe $100,000. How could you pay for a child that you had no knowledge of? And they think that that's legal. These maniacs, because all they care about is the money. All right, that's a lot of money for them, $100,000. Then they got to get money from the federal government. Okay, they have to also prove that the petitioner is standing in court, meaning that the petitioner introduced evidence of what? An injury in fact. Okay, all right. What can you do to prove the court must vacate? File a motion to vacate default judgment. Use Federal Rule 60B1. Okay. Okay, 1 second here. I tell you, sometimes I forget that I'm in front of a friggin' computer when I'm speaking to you guys, and so I'm remembering now. So all you gotta do is look it up. Federal Rule 60B, right? Relief from judgment or order. Okay. 60B, grounds from a final judgment, order, or proceeding. On motion and just terms, the court may relieve party, blah, blah, blah. Okay, so let's get mistake, inadvertence, surprise, or this is what excusable neglect. That's what we're looking at. All right. Here's another one, 64, judgment is void. Fraud, stay away from that because fraud could be considered a crime, and they will rather do anything that they can not to fine for that, or court lacking jurisdiction, okay, because they could be sued for that. Okay, the judicial immunity is a presumption, but a judge can be sued if the judge is acting in complete absence of jurisdiction. I believe that's Stump versus Sparkman case law, say the Supreme Court. Okay, uh, so right there, 60B, demand the court prove you acted willfully. That's huge. All right, that is huge because the Supreme Court has definition um, for willful, the definition of willful. Okay, let me hold on, guys. Another thing I just remember, I could go. I just I always had this. You guys have it. So those of you that have my paperwork, you have this. Okay. All right. All right. Motion to vacate default judgment. Hang in there. Here we go. Okay. All right. All right. It's an adjudicated fact, United States versus Bishop, right? The Supreme Court has defined willfulness as the voluntary, intentional violation of a known legal duty. Okay? Intentional violation. How are they going to prove that? Okay? They can't prove it, especially if you didn't have knowledge of a child, or in the case of default judgment, if you had no knowledge of the proceeding, how can they say you intentionally violated a known legal duty to appear in court? I understand. So that's what they have to prove. Okay. All right. So you get again. I just showed you that cite dismissal. Right. The petitioner failed to state a claim. All right. So you could file aside from the if you're going to go to court, right, to vacate a default judgment, you might as well file a dismissal at the same time. Okay. Always demand the court clarify its reasons to dismiss. Okay, I get so many emails from you guys. Rick, they're dismissed. What do I do now? And I've said this so many times. And you know what the thing is? This is what I know is going on. People don't watch all my videos. Okay, you get bored, whatever. But listen, guys, those days are over. Okay, I got people email me. I got one guy. I checked the email. He sent me over 60 emails. This guy, 60 emails. Okay, and stupid me, I answered him. That's the reason why he got the 60. That ain't happening anymore. Okay, I'm gonna start doing what other channels do and start charging people money for email because I'm tired of people being lazy. And also you gotta start getting off your butt and do your own work. Okay, this channel didn't exist 3 years ago, so you're lucky that I'm around to give you this information. But you know, especially with my paperwork and my videos. I've covered this many times. So if you got a dismissal, what do? You file an objection. I've said that so many times. I have it in the slides too. All you got to do is go back and check my videos. I guarantee you'll come across a video that says, what to do when they dismiss your paperwork. You file an objection. All right. And then in the objection, you're going to demand the court clarify its reasons, demand discovery of evidence of standing. What evidence are we looking for? We're looking for evidence of an injury in fact. No injury in fact, no minimum of standing, no jurisdiction, no default judgment. Okay, you also got to find out if the proceedings are complying with expedited processes under 45 CFR 303-101, which is where the hell is it? Right here. Okay. Expedited process. See, the reason why they get away with this, excuse me, is what they do is they put it on paper, right? They put these things on paper saying, okay, we're going to do expedited processes, but, and all these things, and then they say, safeguards. This is the key thing right here, all right? So it's 303.101 subsection C, safeguards. This is what supposedly makes all of this work, but it's almost impossible. Okay, so safeguards, paternities, and orders established by means other than full judicial process must have the same. How can an other than judicial process have the same force and effect under state law? It doesn't have the same force and effect. In other words, I talk about administrative. An administrative order does not have the same force and effect as a judicial order. It's impossible. Okay? But they put it on paper so it looks like it's legit. Here's another favorite of mine. This is the key one. The due process rights of the parties involved must be protected. Well, how the hell are your due process rights being protected if you're standing in front of a fake judge and there's no jury listening? Due process requires a judgment by peers. Okay? The Supreme Court says that, not Rick. And I'm going to prove it to you. Okay? It should be in here. I mean, I'm just opening a random. It should be in there because I cite this so many times. All right, this is due process requiring an injury in fact. All right, this is the case law that the child support that they take from you does not go to the parent, it goes to the state. Okay, that's another scam. Of course, I picked the one that doesn't have it. Isn't that how it always works with Rick? Okay. Okay, of course not me. There's no such thing as shortcuts, guys. There's one thing I learned about me. Whenever I take shortcuts, it takes me twice as long. So let's just do this the right way. Here we go. All right. All right, what case we're talking about? We're talking about Murray's. Here it is, finally. Jesus Christ. All right. The words due process of law were undoubtedly intended to convey the same meanings as by the law of the land and the Magna Carta. The Constitution, which had been adopted by the several states before the formation of the federal Constitution, following the language. So this had to be, but by the judgment of peers or by the law of the land. This is the Supreme Court. I cite it all the time. This is the definition of due process, a judgment by peers. The New York State Constitution has it in there as well. Okay, so that means, okay, so it says that the due process rights of the parties involved must be protected. How the hell? So if a fake judge is issuing a support order, is that a judgment by peers? No. BS. Okay? It's BS. They're also supposed to take testimony and establish a record. So if there's a default judgment, they must be taking testimony from the petitioner. They must be showing you the evidence introduced by the petitioner. It's not just because you don't show up and they're going to issue an order. There has to be a proceeding happening. So that means that, the petitioner's attorney is going to be like, Your Honor, may I introduce for the record, exhibition, blah, blah, blah. That's what they're supposed to do. And you're going to demand a copy of that. And if they don't provide it for you, they're supposed to vacate the default judgment. Okay? All right? All right, support proceedings are in accordance with, we went over this, okay? Just read this. State law includes the state constitution where you reside, which means the state constitution says, and it does, that you cannot be deprived of property unless by a judgment by peers. Just went over that. Adjudicated facts by Supreme Court. All right, Lujan. Okay, this is the other adjudicated fact for willful. I had it the whole time. Cheek, I like this one better. The standard for the statutory willful requirement is the voluntary intentional violation of a known legal duty. Well, it's the same thing. Okay? So they have to prove your act was willful. How can it be willful if I didn't know about it? If I knew about it, I would have been here. Right? Okay? You must file affidavit of service. Any motion, you got to file an affidavit of service. Have a friend or family member 18 years or older not involved in the matter. Fill out the affidavit of service, right, in front of a notary public, and then what you're going to do is you're going to write down what you're mailing, motion to vacate default judgment. You dropped it in a depository in care, custody, and control of the United States Postal Service, and then you sign it. And by the way, if you have my paperwork, you have an affidavit of service. Just read it, follow the instructions. Okay, so there we have it. All right. Slide 1, slide 2, slide 3, slide 4, slide 5, slide 6, slide 7, slide 8. And this covers basically how to get a default judgment vacated. Many of you have it. It's not that hard. Okay, you could file a motion at any time. Okay, so you could go to the court and file this immediately. All right, and say, listen, I have a default judgment entered against me. I want to get it vacated. I'm filing this. All you have to do is show proof that you served the other party, and you could demand a hearing. All right, usually they give you about 21 days. Okay, but you can look it up. Usually about 21 days. I mean, because you gotta show proof. You gotta give the other party time to respond. That's why it takes about 21 to 30 days. All right, and you just write down in the that you wish to have a hearing within 30 days. Okay, all right, and that's about it. All right, guys, enjoy the rest of your day. Bye.